company subject to picketing if there is a labor dispute with a contractor is found to be a joint employer? And if so, what are the limitations, if any, on the picketing?
I mean, there are a lot of variables that happen when we talk about picketing, and some of those changes I think that Dean was talking about under the last board changed what the heck picket means. We used to think we knew what a picket meant because the guy would have a picket sign and they'd be walking up and down, and now that's in some situations that's not a picket anymore, according to the NLRB. That's just somebody having informational discussion and just information purposes. So. But the general rule is if you're not a party to a labor dispute, you're not supposed to have a picket on a third party, interfere with that person for the purpose of trying to stop people from going across. So there are different rules for strikes and picket lines that go across third parties, non-employers that are around there. But what happens under the joint employer standard that we've just stated is that if you are a joint employer and you have a different site that is now in question, that potentially could be roped into the traditional areas that are fine for little informational picketing, or even more than that, just regular picket lines. So you have to be careful and understand who is a joint employer, do your assessment, as Dean was saying, go through your documents, find out, and I think sit down and take a look at your vulnerability points of where a picket could go. So the answer in the short and long of it is yeah, you possibly could be the target of a picket from a union resulting from a third party's labor dispute that you might be rolled up into under this situation.